In the complex and often turbulent world of United States immigration law, policies can change with little fanfare, sometimes with barely a whisper outside the walls of government offices. Yet, these seemingly minor adjustments can ripple outward, touching the lives of millions in ways that are both profound and deeply personal. Immigration law in the U.S. is a living, breathing system, one that is constantly evolving, shaped by political winds, public sentiment, and the priorities of those in power. For many, these changes are invisible, buried in legal memos and agency handbooks. But for immigrants and their families, the impact can be immediate and life-altering. The stakes are incredibly high. A single policy shift can mean the difference between security and uncertainty, between building a life in America and facing the threat of being uprooted from everything familiar. For millions of immigrants, every new rule or guideline is a source of anxiety, a potential turning point in their journey. One such change, subtle in its announcement but seismic in its consequences, occurred during the Trump administration. It fundamentally altered the way United States Citizenship and Immigration Services, or USCIS, handles cases where an individual's application for an immigration benefit is denied. This was not a headline-grabbing overhaul, but rather a quiet recalibration of the machinery that processes the hopes and futures of so many. This wasn't a law passed by Congress, debated in the halls of the Capitol, or a dramatic executive order signed on television for the world to see. There were no grand speeches or sweeping gestures. Instead, the change came quietly, almost invisibly, through the internal workings of a federal agency. The shift was detailed in a policy memorandum issued in 2018, a document that, on its surface, might have seemed like just another piece of bureaucratic paperwork. But within its pages, the memo contained instructions that would reshape the landscape of immigration enforcement in the United States. This new directive instructed USCIS officers to issue a Notice to Appear, or NTA, much more broadly than ever before. Previously, receiving an NTA was relatively rare for those simply seeking a benefit. Now, a routine denial could become a direct pipeline to deportation proceedings, thrusting countless individuals into the daunting world of immigration courts. Before this change, USCIS was primarily seen as a benefits-granting agency. Its mission was to review and adjudicate applications for green cards, work permits, and citizenship, essentially to help people take the next step in their American journey. The agency was not, at its core, an enforcement body. The process was straightforward. People submitted their paperwork, USCIS reviewed it, and if all was in order, the benefit was granted. If not, the application was denied, and the individual was left to figure out their next steps. For many, this meant living in a kind of legal limbo, but not necessarily facing immediate removal. If an application was denied, the individual was often simply out of lawful status. They might have to leave the country, or they might try to find another path to legal status. But crucially, they were not automatically placed into removal proceedings. The denial was a setback, not a summons to court. The responsibility for initiating deportation fell largely to other agencies, most notably Immigration and Customs Enforcement, or ICE. ICE officers would decide whom to target for removal, often focusing on those with criminal records or who posed a threat to public safety. This created a kind of gray area, a space where many individuals, though technically without legal status, could continue living in the United States. They went to work, raised families, and contributed to their communities, sometimes for years without facing an immediate threat of deportation. For some, it was a precarious existence, but it allowed them to remain part of the fabric of American life. The new policy, however, effectively erased that gray area. By instructing USCIS officers to issue NTAs in a much wider range of cases, the agency merged its traditional role as a benefits adjudicator with that of an immigration enforcer. Suddenly, the same office that processed your green card application could also initiate your removal from the country. The Trump administration framed this change as a necessary step to enhance immigration enforcement and ensure the integrity of the legal immigration system. Officials argued that it was essential to prevent people from exploiting the system, to close loopholes, and to send a clear message that the rules would be enforced consistently. The logic was straightforward. If someone applied for a benefit, was found ineligible, and had no other legal basis to remain in the country, they should be placed into removal proceedings. This, the administration said, was about fairness and upholding the law. This approach aimed to close what officials saw as a loophole that allowed individuals with denied applications to remain in the country unlawfully. By tightening the process, They hoped to deter people from submitting applications they knew would be denied, and to ensure that only those with a legitimate claim to stay would remain. It was presented as a common-sense measure to streamline enforcement and discourage frivolous applications. The administration argued that this would make the system more efficient, reduce backlogs, and restore public confidence in the immigration process. For the administration, it was about consistency and applying the full letter of the law to every case that came before a USCIS officer. No more exceptions, no more gray areas, just a clear, predictable process. However, for immigrants, their families, and their legal advocates, this policy shift represented a seismic and alarming development. It meant that a single misstep, a missing document, a misunderstood question, or a change in personal circumstances could have devastating consequences. The change transformed USCIS from a somewhat neutral bureaucratic entity into an arm of immigration enforcement. The agency that once symbolized hope and opportunity now became, for many, a source of fear and uncertainty. A simple mistake on a form, a misunderstanding of complex eligibility criteria, or a denial of an extension could now trigger a direct path to an immigration court. The margin for error shrank dramatically, and the consequences of even minor mistakes became far more severe. The stakes of every single application skyrocketed. Each form, each supporting document, each answer to a question could be the difference between staying and leaving, between safety and upheaval. The fear was that this would not only affect those who were knowingly trying to game the system, but also sweep up people who made honest mistakes or who were simply unlucky. Even those who tried to follow every rule, who sought legal advice and double-checked their paperwork, could find themselves at risk if they misunderstood a requirement or if their circumstances changed unexpectedly. For many, the arrival of a letter from USCIS became a moment of dread. What once might have been a routine denial now carried the weight of a potential summons to court, a call to defend their right to remain in the only home they may have known for years. A denial letter was no longer just a no, it was a summons to court to fight for your right to stay in the country. The quiet shift in policy had loud, far-reaching consequences, echoing through families, communities, and the very fabric of American society. For many, it marked the end of a sense of security and the beginning of a new era of uncertainty, one where every decision, every application, and every piece of mail could change the course of their lives forever. To truly grasp the significance of recent changes in immigration policy, we first need to understand the foundation of the entire removal process, the Notice to Appear, or NTA. This document is not just a routine letter or a simple administrative formality. Instead, it is the very first step in a process that can have life-altering consequences for individuals and families. The NTA is the official document that signals the government's intent to initiate removal proceedings against a non-citizen, and it marks the beginning of a complex legal journey that can determine whether someone is allowed to stay in the United States or is forced to leave. An NTA is not just a simple notification, it is the official charging document that the United States government uses to begin formal removal proceedings against a non-citizen. Think of it as the equivalent of an indictment in a criminal case. When someone receives an NTA, it means the government has formally accused them of violating immigration law and is now seeking to remove them from the country. This is a serious legal action, and the consequences can be profound, affecting not only the individual, but also their family, their community, and their future. The document itself is formally known as Form 1862, and its issuance means the government believes an individual is removable from the United States. The moment this form is issued, the recipient's legal status changes dramatically. They are no longer simply an applicant for a visa or a green card. They are now a respondent in a legal case with the burden of defending themselves against the possibility of deportation. Receiving an NTA is the first step in a long and often daunting legal battle in immigration court, a specialized federal court system that is part of the Department of Justice. Immigration court is unlike any other court in the United States. It is a unique and highly specialized arena, with its own rules, procedures, and challenges. For many, the experience of being summoned to immigration court is overwhelming and intimidating, especially for those who may not speak English fluently or who are unfamiliar with the American legal system. The NTA contains critical information that forms the basis of the government's case. Every detail included in the document is important, and the way the information is presented can have a significant impact on the outcome of the case. The NTA is not just a list of accusations, it is a carefully crafted legal document that sets the stage for everything that follows in the removal process. It lists the individual's personal details, such as their name and country of origin. These details may seem straightforward, but they are essential for establishing the government's case and for ensuring that the right person is being charged. Any errors or inconsistencies in this section can lead to confusion or even legal challenges later in the process. More importantly, it outlines the specific factual allegations against them. For example, that they entered the country without permission, or that they overstayed a valid visa. These allegations are the foundation of the government's case, and they must be addressed and contested by the respondent. The NTA may also include details about when and how the person entered the United States, what type of visa they had, and any other relevant facts that the government believes support its case for removal. It also specifies the charges of removability, citing the particular sections of the Immigration and Nationality Act, or INA, that the government claims the person has violated. These legal citations are crucial, as they determine the specific grounds on which the government is seeking removal. The INA is a complex and lengthy piece of legislation, and understanding which sections apply can be challenging even for experienced attorneys. For the respondent, these charges are the legal basis for the government's case, and they must be prepared to respond to each one in court. Finally, the NTA summons the individual to appear before an immigration judge on a specific date and time to answer these charges and defend themselves against deportation. This court date is not optional. Failure to appear can result in an automatic order of removal, which means the person can be deported without even having a chance to present their case. The pressure and anxiety that come with receiving such a summons can be immense, especially for those who have never been involved in legal proceedings before. It is the official starting gun for a process that will determine if they can legally remain in the United States. For many, this process can take months or even years, involving multiple court appearances, legal filings, and in some cases, appeals. The stakes are incredibly high, as the outcome can mean the difference between staying with loved ones in the United States or being forced to return to a country they may not have seen in years. The NTA process itself is adversarial. This means that, much like in a criminal trial, there are two opposing sides: the government, which is seeking removal, and the respondent, who is fighting to stay. The courtroom is a place of high tension, where every word and every piece of evidence can make a difference. The judge acts as a neutral arbiter, but the burden is on the respondent to prove why they should not be removed. On one side is the United States government, represented by an attorney from Immigration and Customs Enforcement, or ICE. These attorneys are highly trained and experienced in immigration law, and their job is to present the government's case as forcefully as possible. They have access to resources, legal research, and institutional knowledge that can make them formidable opponents in court. On the other side is the individual known as the respondent. The respondent may be a recent arrival, a longtime resident, or someone who has lived in the United States for decades. Regardless of their background, they now face the daunting task of defending themselves in a legal system that is often confusing and unforgiving. Unlike in criminal court, respondents in immigration court do not have a right to a government-appointed lawyer if they cannot afford one. This means that many people must represent themselves, even though the stakes are just as high as in many criminal cases. The lack of legal representation can be a major disadvantage, as immigration law is notoriously complex and difficult to navigate without expert help. They must either hire a private attorney, find free legal assistance from a non-profit organization, or represent themselves. For those who cannot afford a lawyer and cannot find free help, the prospect of facing a government attorney alone in court can be terrifying. Many respondents do not fully understand their rights or the legal process, and this lack of knowledge can have devastating consequences. This creates a significant power imbalance, as individuals are forced to navigate an incredibly complex and unforgiving legal system, often against a trained government prosecutor, with their ability to remain with their family and community hanging in the balance. The emotional toll on respondents and their loved ones is immense, as every hearing and every decision can bring them closer to either relief or removal. Therefore, the NTA is far more than just a piece of paper. It is a document that carries enormous weight, both legally and emotionally. For many, receiving an NTA is one of the most frightening moments of their lives, as it signals the start of a process that could end in separation from family, loss of livelihood, and return to a country they may no longer know. It is a legal instrument that fundamentally alters a person's life, placing them in a defensive posture against the full weight of the federal government. The NTA transforms the recipient from a hopeful applicant or a long-time resident into a respondent in a high-stakes legal battle. The fear, uncertainty, and stress that come with this transformation are difficult to overstate. It initiates a journey through a backlogged and often bewildering court system where the rules are complicated and the outcomes are life-changing. Immigration courts across the country are overwhelmed with cases, leading to long delays and uncertainty for those waiting for their day in court. The process can drag on for years, with multiple hearings, rescheduled dates, and shifting legal standards. For many, the wait itself becomes a form of punishment, as lives are put on hold and futures remain uncertain. The moment an NTA is issued, an individual is no longer just an applicant for a benefit. They are a respondent in a legal case, fighting to avoid being forcibly removed from the country they call home. This shift in status is profound, and it brings with it a host of new challenges, responsibilities, and risks. The stakes could not be higher, as the outcome of the case will determine whether the person can continue to build a life in the United States or must leave everything behind. This context is essential to grasping why expanding the authority to issue these documents was such a monumental policy decision. The NTA is not just a bureaucratic formality, it is the gateway to a legal process that can change lives forever. Understanding what an NTA is, how it works, and what it means for those who receive it is the first step in understanding the broader implications of immigration policy and the real human impact of these decisions. The expansion of NTA issuance authority under the Trump administration mattered immensely, not just as a bureaucratic adjustment, but as a seismic shift in the way the United States government approached immigration enforcement. This policy change was not a minor tweak or a technical update buried in the fine print. Instead, it represented a fundamental reimagining of the relationship between immigrants and the agencies tasked with processing their applications. For many, it felt as though the ground had shifted beneath their feet overnight, because it fundamentally changed the risk calculation for hundreds of thousands of immigrants interacting with the legal system. The stakes of every decision, every form, and every appointment were suddenly much higher. Where once there was anxiety, now there was fear that a single misstep could have life-altering consequences. Suddenly, any application filed with Uscis became a high-stakes gamble. The process, already daunting and complex, now carried the added weight of potential removal proceedings. For many, the act of seeking legal status or renewal was no longer just about paperwork, it was about risking everything they had built in the United States. Before this policy, an individual applying to change their status, for instance from a student visa to a work visa, might face a denial if they didn't meet the stringent requirements. The process was stressful and the outcome uncertain, but the consequences were generally limited to the denial itself. While disappointing, the consequence was usually just the denial itself. Applicants could regroup, seek legal advice, and sometimes reapply or find another path forward. The system, while imperfect, allowed for a measure of resilience and hope. They would fall out of status, but they were not immediately targeted for deportation. There was a window, sometimes brief, sometimes longer, during which individuals could try to fix their situation, appeal, or make arrangements without the immediate threat of being placed in removal proceedings. The new policy, however, meant that the same denial would now automatically trigger an NTA, placing them directly into removal proceedings. This was not just a procedural change, it was a transformation of the entire experience of interacting with the immigration system. The fear of a simple mistake now loomed over every applicant. This shift had a chilling effect on people who were otherwise trying to follow the law. Many immigrants who had always tried to do things the right way suddenly found themselves questioning whether it was even safe to apply for benefits or status adjustments. The risk of being swept into the deportation system for a technical error or misunderstanding was simply too great for some to bear. Imagine a foreign student who is about to graduate and applies for a work visa. This student has spent years studying, building friendships, and contributing to their campus and community. Their future, and perhaps the future of their family, hinges on the outcome of a single application. If their application is denied for any reason, perhaps a technical error, a missing document, or a missed deadline, they would not only lose the job opportunity, but would also be summoned to immigration court. The denial, which once meant disappointment and uncertainty, now meant the very real possibility of being forced to leave the country they had come to call home. The same rule applied to someone seeking to extend their stay as a tourist, or to adjust their status to that of a legal, permanent resident through a family member. Even those with deep roots in the United States, who had followed every rule and paid every fee, were now at risk. Every interaction with the very agency designed to grant legal status became a potential trapdoor into the deportation system, creating widespread fear and uncertainty within immigrant communities across the nation. The sense of safety and trust that is essential for any functioning legal system was eroded, replaced by suspicion and anxiety. Community organizations and legal aid groups scrambled to respond, holding emergency information sessions and distributing flyers warning immigrants about the new risks. The message was clear: even a small mistake could have devastating consequences. Furthermore, the policy disproportionately affected those who were most vulnerable. Elderly immigrants, parents with young children, and those with limited resources were often the least able to navigate the new, harsher landscape. Immigrants with limited English proficiency, who already faced significant barriers in understanding complex legal documents, were at an even greater disadvantage. The risk of misunderstanding a form or missing a critical instruction was ever present. Those with little access to expensive legal counsel, who could not afford to hire an immigration attorney, were left to navigate the labyrinthine process on their own. For many, the cost of legal help was simply out of reach, leaving them exposed to the full force of the new policy. Or those simply unfamiliar with the labyrinthine rules of United States immigration law were at the highest risk. The system, with its ever-changing requirements and complex forms, was difficult even for experts to master. A simple, honest mistake on a complex form could now have the catastrophic consequence of deportation. The margin for error, always slim, had all but disappeared. Legal hotlines and advocacy groups reported a surge in calls from panicked immigrants, desperate for guidance and reassurance. Many were afraid to even ask questions, worried that seeking help might somehow put them at greater risk. For example, an applicant for a U visa, a special visa for victims of crime who have assisted law enforcement, could see their application denied and then be placed in removal proceedings. This was especially cruel, as these individuals had already suffered trauma and were seeking protection. This created a cruel irony, where a victim seeking protection from the government could end up being targeted for deportation by that same government. The very system meant to offer refuge became a source of new danger. Advocacy groups and legal experts decried the policy as unjust and counterproductive, arguing that it undermined public safety by discouraging victims and witnesses from coming forward. Ultimately, this policy matters because it weaponized the administrative process. What was once a neutral, bureaucratic function became a tool for enforcement, blurring the line between service and surveillance. It turned a bureaucratic function, reviewing applications, into an enforcement mechanism. The people processing paperwork were now, in effect, gatekeepers to the deportation system. This change burdened an already overwhelmed immigration court system with a flood of new cases, many of which involved individuals with deep ties to the United States, including United States citizen children and spouses. The courts, already struggling with massive backlogs, were pushed to the breaking point. Immigration judges found themselves facing dockets filled with cases that in previous years would never have reached the courtroom. The human cost of these delays was immense, as families waited months or even years for resolution. It raised fundamental questions about fairness, due process, and the very purpose of Uscis. Was the system designed to help people navigate the law, or to punish them for failing to master it? Was the agency's primary role to help people navigate the legal pathways to immigration, or was it to identify and funnel people into the deportation pipeline? The answer for many seemed to have changed overnight. The 2018 policy shift tilted the answer firmly toward the latter, with profound and lasting impacts on the lives of countless individuals and families. The legacy of this change continues to shape the experiences of immigrants across the country, serving as a stark reminder of how policy decisions can ripple through communities, altering destinies and reshaping the very meaning of justice and belonging in America.